Section 2. Inventors and patent owners. Who is an inventor? Now, who owns the rights of a patent? The person who conceived the invention is the inventor, that for sure. Whereas the person or the company that files the patent application will be the applicants. After the granting of the patents, the person or the company would become the holder or owner of the patents. You see, it's highly possible in practice the inventor may also be the applicant. However, in many other cases, the inventor and the applicants are often different entities or individuals. In practice, inventors or employees of a company, of a research institutes, or even employee of a university. So, in practice, the applicant for an invention is often the company or the research institutes that employs the inventor. In many countries, the inventions developed in the course of employment are automatically assigned to the employer. So, in the case of employee inventions, pay attention, the ownership of the right to apply for patents and the patent rights granted by patent office would usually be owned or automatically being assigned to the university. In some other countries, the employee inventions might not be automatically being owned by the employer. The ownership of the employee inventions and patents could be stated in the employment contract. In some cases, for example, if there is no employment contract which clearly states the ownership of an invention in the course of employment, the inventor may retain to exploit the invention. It means if there is no specific clause in the employment contract to define who owns the rights to apply for a patent, who owns the patent rights, the employee, the inventor, may retain the rights to exploit the invention. But the employer, under patent law, is given a non-exclusive right for its internal purpose. This is called the shop rights. Therefore, it is important to find out about the specific legislation in the relevant country and to ensure that employment contracts deal with issues of ownership over employee invention to avoid possible disputes. Under Article 6 of the Patent Law of China, it is provided that an invention made by a person in the course of employment to execute the tasks of the entity to which he belongs, or made by him mainly by using the material and the technical means of the entity, is deemed as an employee invention. So pay attention here. This is the legislation which define the term of employee invention in China. So here, an employee invention is defined as an invention made by the person in execution of the tasks of the entity. Number two, the invention is made by the person majorly using the material and the technical supports or devices owned by the entity. You see, there are two circumstances under which the invention executed by the inventor would be defined as employee invention. For an employee invention, the rights to apply for a patent will be owned by the employer, by the entity, by the company. After the patent is granted, the employer of the person, which could be an entity or a company or a research institute, shall be the patentee, the owner of the patents. So the first sentence of this paragraph is to define what is an employee invention. The second part of this paragraph is to define the rights to apply for patents and the ownership of the patents. But be careful. This is a legislative arrangements concerning employee inventions in China. This might not be the case in other countries. It is also possible in practice that a company may not have its own employee to do the research and development. The company may simply hire an external researcher or engineer or just another company to do the research and the development. In many countries, the inventions developed by an independent contractor hired by a company to develop a new product or process would own all rights to the invention unless otherwise specifically agreed in written forms. It means unless the contractor has a written agreement with the company assigning the invention to that company, the company will have no ownership rights in what is developed, even if the company already paid for the research and development. I'll put another way. You pay amount of money to a researcher to the research for you, and that researcher come up with an invention. Would own the rights to patent that invention? Well, unless it is agreed in advance in the contract between you and that individual researcher. Otherwise, the rights over the invention and the rights to patent the invention. And if patented successfully, the patent rights will be owned by that researcher, not by you. Therefore, to sign the contract hiring that independent researcher, that external engineer, you must be very careful to have the contract clearly stating the ownership issue over what is to be developed. This is also the legal arrangements under Chinese patent law. So here, the inventions made by an independent contractor who is, who is hired by a company is different from the invention made by the employee of the company. There are different sets of legislative arrangements. You have to be careful with the specific legislations in different countries.